charges contained in counts 1 through 3, there are also attendant firearm specifications. The state must prove beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing those offenses and displayed the firearm, brandished the firearm, indicated that he possessed the firearm, or used it to facilitate the offense. Firearm means any deadly weapon capable of expelling or propelling one or more projectiles by the action of explosive or combustible propellant. Firearm includes an unloaded firearm and any firearm that is inoperable, but that can readily be rendered operable. When deciding whether a firearm is capable of expelling or propelling one or more projectiles by the action of an explosion or combustible propellant, I may rely on circumstantial evidence, including but not limited to the representations and actions of the defendant while exercising control over the firearm. As to the charge of improper handling of a firearm in a motor vehicle, in case 2206-2276, the defendant must have knowingly transported or had a loaded firearm in a motor vehicle in such a manner that it was accessible to the operator or any passenger without leaving the vehicle, and the accompanying forfeiture specification of the Riley Defense, Inc., R8K 47, serial number B11765. I've carefully considered all of the evidence and the exhibits admitted during trial. I've weighed the credibility of the testimony of all the witnesses, including the testimony of the defendant. It is my province to believe all, none, or some of the testimony of each witness, as well as the physical evidence that has been presented and the exhibits admitted during trial. I have considered the physical evidence and whether it corroborates the testimony of each witness in deciding which, if any, of their testimony I choose to believe. I find there is no credible evidence that Ms. Westover threatened or even tried to harm the defendant. There was credible evidence that the defendant had hold of Ms. Westover either by, as to her upper torso, whether by her hair, neck, or shoulder. Ms. Westover was shot 3 times, and the most serious injury which caused her death was a gunshot wound to the back of her neck that was approximately 8 to 10 inches away and included evidence of stippling near the entrance wound, and the trajectory of that propellant was from back to front, right to left, with a downward angle. While the defendant's testimony at times was believable, and there were portions of his testimony that he seemed genuinely convinced of the testimony he was presenting, I find a majority of that testimony was completely self-serving, illogical, and completely uncorroborated by the physical evidence and exhibits admitted during trial. In reviewing Exhibit G of the defense's exhibits, there was no credible evidence that you were injured or that your clothes were torn by Mr. Cruz, the machete-wielding aggressor. While you fled the scene, both Adam Wright and Brian Fielders had already both fled, and you still possessed the firearm. Furthermore, once you dropped from the porch, you leisurely strolled away with no signs of panic or fear that you testified you were feeling during the trial. Your statements to detectives the night you were arrested contained various inconsistencies, not to mention were completely inconsistent with your testimony during this trial. Lastly, your actions in fleeing that night with Miss Westover's purse and the firearm, and changing your appearance and hiding out in your cousin's house for over a month shows a consciousness of guilt. This court is left to weave together the offensive events of July 25th, 2022 from all the testimony, the physical evidence, and the exhibits admitted during trial. Based on everything presented at this trial, the more logical sequence of events is that for whatever reason, including being high on methamphetamine, not having slept for days due to that methamphetamine use, and the paranoia that comes with the use of methamphetamines, you shot and killed Toni Westover. And after shooting her, you were attacked by Brian Fielder, and when you had him down on the floor, he bit you while trying to get the gun away from you and from your grasp. According to Ashley Bratton, who testified 2 times, and including yesterday, Adam Wright was on his way out of the back bedroom with a firearm and returned, and upon finding you on top of Brian Fielder, hit you with the firearm and then fled. Everyone fled through that back bedroom because Toni Westover was left dead, hanging over the side of that couch, and was blocking the front door. Therefore, I'm left with only one conclusion. The state of Ohio has proved beyond a reasonable doubt that you committed the crime of improper handling of a firearm in a motor vehicle on June 5th, 2022, and furthermore, by clear and convincing evidence, I'm ordering forfeiture of the Riley Defense, Inc., RAK 47. As to all the charges in the indictment in case 2209-3102, I have considered each count uninfluenced by my verdict as to any other count, and I find that the state of Ohio has proved beyond a reasonable doubt that you did not act in self-defense on July 25th, 2022, and that you were at fault in creating the situation, giving rise to the shooting, or attempting to shoot Toni Marie Westover, and or that you used unreasonable force against Toni Westover. Therefore, I find you guilty beyond a reasonable doubt of murder, an unclassified felony as contained in count 1, and the 3-year firearm specification 1 to count 1. I find you guilty beyond a reasonable doubt of murder, an unclassified felony as contained in count 2, as well as the firearm specification 1 to count 2. I find you guilty beyond a reasonable doubt of felonious assault, a felony of the 2nd degree, as contained in count 3 of the indictment, and the firearm specification 1 to count 3. And lastly, I find you guilty beyond a reasonable doubt of tampering with evidence as a felony of the 3rd degree, as contained in count 5. The court having rendered its verdict, I am prepared to proceed to sentencing at this time, if both parties are prepared also. Before hearing from the parties, I do find pursuant to Ohio Revised Code 294125, State versus Johnson and State v. Ruff, that counts 1, 2, and 3 for merge for purposes of sentencing. I find that the defendant's conduct is of similar import and was committed with the same animus. Pursuant to Ohio Revised Code 292914B1G, if an offender is convicted of or pleads guilty to 2 or more felonies, if 1 or more of those felonies are aggravated murder, murder, attempted aggravated murder, attempted murder, aggravated robbery, felonious assault, or rape, and if the offender is convicted of or pleads guilty to a specification of the type described under Division B1A of this section, in connection with 2 or more felonies, the sentencing court shall impose on the offender the prison term specified under Division B1A of this section for each of the 2 most serious specifications of which the offender is convicted or to which the offender pleads guilty, and in its discretion also may impose on the offender the prison term specified under that division for any or all of the remaining specifications. Therefore, I find that specifications to count 1, 2, and 3 do not merge pursuant to 292914B1G. Mr. Perry, would you like to talk to Mr. Nixon about a PSI, or is he prepared to waive that right?
I would, Judge, just a second.
Sure.
Your Honor, you can continue with the sentencing.
All right. For the record, furthermore, I have executed verdict forms as to each and every count and specification, and they will be filed with the with the clerk of courts, excuse me. On behalf of the state of Ohio, which count are you asking to proceed on, counts 1, 2, or 3?
Count 1, Your Honor.
All right. So purposes of sentencing and convictions, count 1, 2, and 3 merge, and we will proceed on count 1 with as an unclassified felony murder under 290302A. On behalf of the state of Ohio, Ms. Easter.
Thank you, Your Honor. The state would like to, the prosecutor would like to speak after the victims, Your Honor. Present today are multiple different individuals. We have 6 different individuals present. 2 would like to speak. But for the record, I would like to say Ray Shreve, Shreve, who is Toni's daughter's father, Isabella Shreve. Father, he was notified. He's at work. He can't make it. However, he says we can proceed because he's glad to let his daughter know that this process will soon be over. So under Marcy's Law, I just wanted to put that on the record. We have reached out, and he's gotten back to us, Your Honor. At this time, who would like to speak first? Would you like them to go to the podium or up?
Here.
Okay. Peggy Westover.
Hi, ma'am. Go ahead. Tell me your full name, please.
My name is Peggy Westover.
Go ahead, please.
Okay, I would like to say the day of the 25th, 22. My daughter was murdered, and it was the worst day of my life and her sister's life, and the life of her little girl. And you know, she wouldn't do anything to hurt anybody or anything. And she was a sweet girl, a beautiful lady. I mean, everything you would want in a daughter. But she just got mixed up with the wrong people. And all that happened. And so, whatever you consider, I'm moved by it.
Thank you, ma'am. Would you state your full name, please? Thank you. Thank you, Ms. Perry.
I do want to speak on behalf of the father here. I have seen Isabella struggle through all of this. She has seen the YouTube, she's seen the videos, and I know he stated that he's not a monster, but in our eyes, in that little girl's eyes, he is a monster. He killed her 2 days after her birthday party. I wrote this about a year ago, but I'm going to kind of adjust it to today. I never imagined that I would be standing here today asking for justice for my sister, Toni. I should not have to do this, and honestly, it's not fair. Quinton, it has been 2 years since you murdered my sister, Toni. I woke up on July 25th, and I felt this feeling of something being wrong when I seen a post on Facebook that said that a 34-year-old girl was killed in Kenmore, and for some reason, I knew it was her. And I called my mom, and I told her, please get a hold of Toni. I have a bad feeling that something bad happened. That day, our life was shaken to its core. And all I could do is scream, no, not her, and cry and ask why. Why Toni? What kind of monster could do this? She was my best friend, the one I was supposed to annoy for the rest of our lives. A second mother. She was so bubbly and full of life. She was a calm person. She never got into a fight in high school. No matter what she was dealing with, she always put other people first. Everyone who knew her loved her, and when she walked into a room, she lit it up. I had so many sleepless nights trying to wrap my head around who could do this and why. Toni was not a violent person, not a criminal record. She was a kind soul, someone who saw the good in everyone, even when they did not deserve it. She didn't deserve this, and our family didn't deserve this, to lose her like this. I always thought it would be us forever, until you robbed us of that. I don't have her to FaceTime, to laugh with. I don't have her to tell me everything's okay when I need her. I didn't get the proper goodbye. When I lost her, I lost a part of my childhood. And a piece of me died that day too. I felt this emptiness, I still do. I started to lose myself. I never imagined our last goodbye would be seeing my sister in a casket, cold and lifeless. It's a memory that I will never forget. It's the face I see. It's the face I see when I close my eyes. The look on her face and how sad she looked. I could barely walk into the room, and when I did, I fell to the ground and I screamed. I was shaking and crying so bad that I had to have my stepdad help me I never imagined this being our last goodbye. It wasn't her time. I'm your sister. She was supposed to be here for me. I looked up to her. You took a little girl's mother away. Imagine telling your child that her mother's never coming home. And then imagine trying to explain to that little girl what happened to her. To her mother. And now we have left is this pendant with her ashes. 12 days before you murdered my sister, Toni, you wrote a post on Facebook, and I'm going to quote what he said. To the younger Jen, remember what choice you make in the street. You got to deal with it on the courthouse sidewalk. Better choices, just saying. And as a man, I stand on my mistakes. And what you said have not only put our family through a lot of trauma, but you also put your own family through a lot. And now you have children being raised without a father. And here we all are due to the choices that you have made. And I speak for my family and for Toni. Are you ready to man up and stand on those mistakes? As Toni's sister and as her voice, I ask the court that justice will be served and that the thanks for this precious life that was robbed of us. And for Toni's little girl, we now have two families that have to say goodbye to a loved one. But the difference is, we don't get to see Toni anymore. I keep asking myself how many years justifies what you've done. And honestly, there's no amount of time that will make us feel any better, because it doesn't bring her back. And at the end of the day, we lost someone special, and we have to live with that for the rest of our lives. And so does that little girl. I hope that what you've done eats you up inside, and I hope her face haunts you. And I hope that one day I can find forgiveness, not for you, but for myself. But today's not that day. I will continue to fight for her and be her voice. I will be at every court hearing regarding this case, even if it's 15 years from now.
Thank you. Who else, Ms. Feaster?
Your Honor, I do not believe any other family members would like to speak. At this time, Your Honor, the state is requesting a minimum of 24 years, Your Honor. That is for the murder. By statute is 15 years to life, and 2 gun specs that shall be served prior to and consecutive. That gets a minimum of 21. The state is asking for the tampering with evidence, not the max, but 2 years to run consecutive, because the defendant was or did go through RAPATA, knew an investigation was likely to occur, and did consciously discard the firearm, Your Honor. And I'm asking for the improper handling, a year on that. Again, not the max, but I would like it to run consecutive because he was out on a capias at that time, and the conditions of bond are normally not to indulge in alcohol or drugs, and he was actively taking drugs at that time, Your Honor. That is where the state comes up with the 24 years to life. This is a tragic situation all around, drugs use in general, but drugs and guns. As Toni's sister stated, now 2 families will be without their loved ones. Isabella lost a mom. Toni's family lost a sister, a daughter, an aunt. Toni will never get to see Isabella grow, get married, have a boyfriend, go to college, or things of that nature, Your Honor. But as Amy stated, the defendant's children will get to see him and visit. That was taken away from Isabella and her family, Your Honor. So that is the sum and substance and the basis for the state's recommendation of 24 years to life.
Thank you. Mr. Nixon, on your behalf.
Your Honor, my family would like to speak.
Sure. Who would like to speak? Come on up. Would you tell me your full name, please? Thank you. How are you related to the defendant? Okay, thank you. Just speak up just a little bit, because there's... Okay.
And I haven't been here for any of the court proceedings. I'm a single mom, and I've been the only one that takes care of me and my family. My kids are grown, but I still do what I can do. I'm not here to ask for pity. It's not a pity party. I do understand the severity of what has been done. It might not be today. First, I would like on mine. So I would like to definitely say my condolences to you all. And it might not be today. No, it might not be tomorrow. It might not be 5 years from now, but maybe one day you will find it in your heart to show mercy and forgive. That I can't do anything but just maybe pray that you will do that. But I thank you for hearing me out, and I just want to say that I don't truly believe in my heart I gave birth to a monster. I won't say that. My mistakes have been my own. A lot of what my children have suffered has been through my own hand. The way I live my life, the way I might have been raising things I've gone through, but at some point we all make our own decisions. I am aware of that as well. And I just ask if the court would show mercy. That's all I'm saying.
Thank you. I appreciate it. Thank you very much, ma'am. Is someone else speaking, Mr. Nixon?
Yes, my sister.
Thank you. Would you tell me your full name?
Here, Nixon.
Thank you, Ms. Nixon. Go ahead.
I am Quinton's sister. I've been with him my whole life. He's 3 years older than me. He, it's mostly seemed like I've been the big sister my whole life. But through this experience, he has shown me strength, power, and I won't take that from him. I lost a child last year, so I can't say, oh, you know, I do know how that feels. And I think the word of the day is accountability. Everybody was where they should have been in this situation. Everything happened the way it should have never happened in this situation. However, I do serve a merciful God. I do believe he is full of mercies. And I do believe that the truth showed itself, and what I ask for is just for grace. That's all. And whatever you do decide, I have to be okay with it. And I too will be here for him, do anything forever. And that's all I have to say.
Thank you, Ms. Thank you, Ms. Nixon. Mr. Nixon, do you choose to make a allocution or a statement at this time? You're not required to. You may if you want to, but that's your choice.
To Miss Westover's family, I'm not a monster, but I do ask for forgiveness. I don't. Nothing I can say is going to help how you guys feel. Please forgive me. To her daughter, I ask for forgiveness. To her mother, I ask for forgiveness. To her sister, I ask for forgiveness. It was me against them. To my mother and my family, I ask for forgiveness.
Forgive me, son.
I have to take responsibility for what the court is holding me responsible for. But it's not. It didn't happen the way that they said it happened. I'm not a monster.
Anything else, sir?
No, ma'am.
All right, having been convicted of the offenses, the bond that has been previously set is revoked. You're remanded to the Summit County Jail, starting with your notice of your duty to enroll as a violent offender pursuant to 290341 of the Ohio Revised Code. You've been convicted of or pled guilty to a qualifying violent offender offense as defined in 290341 of the Ohio Revised Code. You are required to enroll in the violent offender database personally with the sheriff of the county in which you reside 10 days after being sentenced, if you're not sentenced to a prison term. If you were sentenced to a prison term, you must enroll in the database personally with the sheriff of the county in which you reside 10 days after being released from jail. If you're an out-of-state offender, you must enroll in the database personally with the sheriff of the county in which you reside or occupy a dwelling within 10 days of either one, residing in or occupying a dwelling in Ohio or for more than 3 consecutive days, or 2, residing in or occupying a dwelling in Ohio for an aggregate period in a calendar year of 14 days or more. You're required to provide the sheriff with your full name and any aliases you use, your residence address, social security number, any driver's license number or commercial driver's license number or state identification card number issued to you. Information regarding the offense for which you've been convicted of or pled guilty, the name and address of any place where you are employed, the name and address of any school or institution of higher education you attend, the license plate number of each vehicle owned or operated by you or registered in your name, the vehicle identification number of each vehicle, and the description of each vehicle. A description of any scars, tattoos, or other distinguishing marks on your person. You're required to provide the sheriff fingerprints and palm prints, and the sheriff will also obtain a photograph of you at the time of enrollment. After the date of initial enrollment, you're required to re-enroll annually. You must update and/or amend any of the information described above that has changed and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you are initially enrolled. If you change your residence address during the 10-year enrollment period, you shall provide written notice of that change to the sheriff with whom you most recently enrolled and to the sheriff in the county in which you intend to reside within 3 business days of the change of address. You're required to comply with all the above described requirements for a period of 10 years unless your sentencing court determines otherwise. Since your expected address is located in Summit County, you shall enroll in person no later than 10 days after release or sentencing if you're not subject to incarceration with the county sheriff office located at 205 East Crozier Street, Akron, Ohio 44311. You're required to sign this form, not that you necessarily have to agree with it, just that I read it to you in open court. And one of the signed copies is for you to keep.
And the date it there, please, sir.
All right, I'm ready to proceed now. So, Mr. Nixon, you know, the person that's sitting here before me today, I think relatively intelligent, well-spoken, well thought out, is a totally different person that existed in 2022. So whatever led you down the path, A, to associate with these people, but B, down the path of methamphetamine, is clearly why you're sitting here today. I don't know how many times we have to have someone shot and killed in our community before people realize that gun violence has so many unintended consequences, not just to put out the life of the person or injure the person that the gun is being pointed at, but the trickle-down effect of all of those other people that are affected by this, your children, your mother, your sister, Miss Westover's family, her children, her grandchildren, all of those things. And the combination of drugs and guns in this community and staying up for days and all the paranoia that comes with the use of those drugs just baffles me. I believe that you do have sincere remorse. I do believe that having sat in jail for 2 years and reading through the discovery and not necessarily remembering all the events of that night due to your drug-fueled paranoia, that you have convinced yourself that the testimony you gave in this courtroom is truthful. It does not jive, it does not correspond, it is not corroborated by the physical evidence. That being said, I find based on the facts and circumstances of this case in consideration of the relevant sentencing factors, applying the minimum sanction I've determined will protect the public and punish the offender without imposing an unnecessary burden on state or local resources. As to 2206-2276, count 1, improper handling of a firearm in a motor vehicle, I'm imposing 18 months in the Ohio Department of Corrections. I'm not imposing any fines, and the court will take judgment against you for the cost of this prosecution. I'm also ordering, pursuant to specification 1 to count 1, that the Riley defense RAK 47 be forfeited. As to 2209-3102, the state of Ohio having chose to proceed with sentencing on count 1, murder and unclassified felony, I'm imposing a sentence of life in prison with the eligibility of parole after 15 years. Specification 1 to count 1, specification 1 to count 2, I'm imposing a mandatory prison term of 3 years on each count, and pursuant to 2929-14B1G, those offenses will run consecutive and not concurrent to each other and be served prior to and consecutive with the life sentence that you're facing. I'm using my discretion to not impose a sentence on specification 1 to count 3, and I'm imposing a 36-month prison sentence on count 5. I am running both cases concurrent to each other, and I am running count 5 concurrent to count 1 for a total sentence of 21 years to life in the Ohio Department of Corrections. Upon completing your prison sentence, as to the tampering, you're facing 2 years of discretionary post-release control, which is supervision by the Adult Parole Authority. As to being granted parole, as to the murder charge, that will be left up completely to the Adult Parole Board, and they will decide when and if you are released from prison, or if you, after serving 21 years, or if you're required to serve the balance of your life in the Ohio Department of Corrections. Again, I'm not imposing any fines on this case, but we will take judgment in the amount of the cost to prosecute this case. Your credit for time served in the Summit County Jail will be calculated, and that will be credited towards your sentence that you are to begin serving. You'll be remanded to the Ohio Department of Corrections. Lastly, Mr. Nixon, you are entitled to appeal these convictions. If you want to appeal that, you must appeal within 30 days of today's date. If you want an attorney appointed for you because you cannot afford to hire an attorney to appeal these convictions, the court will appoint one for you. Do you understand those appellate rights?
Yes, ma'am.
And do you wish to appeal?
Yes, ma'am.
And do you wish to have the court appoint you counsel?
Yes, ma'am.
All right, we will do that, and I will reach out and find an attorney qualified to handle this level of an offense, and it will be included in the journal entry, and then that attorney will be in contact with you through the Ohio Department of Corrections. Anything else on behalf of the state of Ohio?
Just one thing, Your Honor, and I may have missed it. I heard the PRC for the improperly.
Oh, yeah, no, so it's 2 years discretionary on both the improper and the
Okay.
tampering. I apologize. But based on the fact that he is subject to the parole board's determination, that would run concurrent with any parole that he's offered or granted by the parole board.
That's all, Your Honor. Thank you.
Anything else on behalf of yourself, Mr. Nixon?
Pardon me?
Did you want to say anything else before we adjourn?
No, Your Honor.
All right, so I think you're a smart, intelligent person, and it would, I think you have the opportunity to take advantage of some programming while you're there. Go to school, get a degree, become a lawyer. I don't know, but I hope God has mercy on your soul, Mr. Nixon. We're adjourned. Here's the verdict forms. 808 days credit, by the way. There you go.